Okay, well, good afternoon, everyone. My name is Martin Phillipson. I'm the Dean here at the College of Law, and I'll also be the moderator for today's event. Before we begin, I'd like to acknowledge that we're in Treaty 6 territory in the traditional homeland of the Métis, and we pay our respects to the First Nations and Métis ancestors of this place, and we reaffirm our relationship with one another. I'm delighted to welcome you today to the 25th Annual Saskatchewan Law Review Lecture. I was at the first Law Review Lecture in 1999. That was the year I was appointed to the faculty. And I have to say, it wasn't very exciting. And I hate to say this, but Steve Wadhams, who, the famous Wadhams on contract, gave a lecture. And Don Clark, who some of you will remember, was our contracts prof and was delighted to have Steve Wadhams there. And Don, I think, fell asleep halfway through. But anyway, I have absolutely no doubt that today's lecture will not be sleep-inducing. I'm absolutely convinced of that. I hated contracts law. We all have our skeletons in our transcript cupboards, and contracts was mine. So maybe that was it. Anyway, let's get professional, Phillipson. I do want to acknowledge a few guests who are with us today, members of the judiciary. Chief Justice Bob Lura of the Saskatchewan Court of Appeal, Chief Justice Martel Popescu from the Saskatchewan Court of King's Bench. We have Judge Michelle Brass from the Saskatchewan Provincial Court in Estevan, and also retired Judge Moran from the Cree Court. And we have some words of welcome in a moment. It means a great deal that you've joined us today to share your knowledge, experiences, and others. But I also, in particular, want to welcome our guest speaker, the Honourable Michelle O'Bonsawin, for joining us today. It's a real privilege to welcome you to the college, and we're delighted to have you here. And I would now like to introduce, as this is the Law Review Lecture, to introduce our three managing editors of the Law Review, Cadence Marley, Kennedy Marley, and Laura Rask. And I'll invite Kennedy and Cadence up to introduce our speaker today and tell you a little bit more about the Law Review.
Okay, I'm a little shorter than Dean Phillipson. Good afternoon, everyone. My name's Cadence Marley. I'm a proud Métis woman from Treaty 4 territory near LeBret, Saskatchewan, and I'm a third-year law student. And saying that out loud, I now realize I never expected I'd appear before the Supreme Court of Canada this early on in my career. And I'm also realizing I'm appearing before all levels of court in this room right now. So no pressure. If anything goes south, it's just recorded, and that's fantastic. So I do feel very fortunate to help introduce a very significant member of our legal community and our Indigenous community today at our lecture. And so I'll just speak to you a little bit about what the Saskatchewan Law Review Lecture is and what it means to this college. The Saskatchewan Law Review Lecture is delivered annually by a distinguished member of our legal community. Some past speakers have included the Honourable Gerald Moran, OC, and former judge of the Provincial Court of Saskatchewan, the Honourable David Lametti, former Minister of Justice and Attorney General of Canada, and the Honourable Rosalie Silberman Abella, of course. The Saskatchewan Law Review provides a vehicle for the publication of researched articles and comments authored by practicing and academic members of the legal profession. It also includes publications by law students and others who are interested in analyzing and publishing on legal matters that are of particular interest to lawyers in our community. Law students get hands-on experience when they're editing legal journals, as they're selected for the student editorial board of the Saskatchewan Law Review. This year, our editorial board is comprised of 18 second and third year law students, most or all of whom I believe are seated in the second and third row here, so welcome today. Our editorial board students select and edit articles for publication, they set policy, and they write papers and case comments for possible publication in the review. The processes of the Law Review help these students learn about legal publishing, and they refine their legal research and writing skills, all while contributing to the completion of their Juris Doctor degrees. Good morning. So as Cadence said, I'm Kennedy, her twin sister. Today we are very pleased to have the Honourable Michelle O'Bonsawin from the Supreme Court of Canada. She is a widely respected member of Canada's legal community with a distinguished career spanning over 20 years. Justice O'Bonsawin was appointed to the Ontario Superior Court of Justice in Ottawa in 2017. Prior to her appointment, she was General Counsel for the Royal Ottawa Healthcare Group for 8 years. And in this role, she developed a thorough understanding of legal issues related to mental health, and she performed significant research regarding the use of Gladue principles in the forensic mental health system. In this role, she also appeared before various administrative tribunals and levels of court, some of which include the Human Rights Tribunal of Ontario, the Consent and Capacity Board, the Ontario Review Board, the Ontario Superior Court of Justice, the Ontario Court of Justice, and the Ontario Court of Appeal. I think that's all of the courts. She began her legal career with the legal services at the Royal Canadian Mounted Police and was then counsel with Canada Post, specializing in labor and employment law, human rights, and privacy law. Justice O'Bonsawin has taught Indigenous law at the University of Ottawa's Common Law program and was previously responsible for the Indigenous Relations program at the Royal Ottawa Healthcare Group. She is a frequent guest speaker on Gladue principles, Indigenous issues, as well as mental health, labor, and privacy law. Justice O'Bonsawin is also the author of various publications. In 2020, she published an article titled, "Access to Justice and Gladue Reports, We All Have a Role to Play in Lawyers Daily." In 2018, she published an article titled, "A Principled Approach, Applying Gladue Principles at the Ontario Review Board in the National Judicial Institute Indigenous Law Subject Collection." In 2016, she published another article titled Canada's Bill C-14 NCR, a knee-jerk reaction to sensationalized not criminally responsible cases in the Canadian Criminal Law Review. And in 2016, she also published an article titled The Mental Health Checklist, a Guide for Members of the Judiciary. Justice O'Bonsawin previously served on the Board of Governors of the University of Ottawa, as well as its executive committee, and as a board member for the Aboriginal Legal Services of the University of Ottawa Legal Aid Clinic. She was an observer member of the membership committee of Odanak First Nation and a board member of the Canadian Institute for the Administration of Justice. She is currently a partner judge for Afghanistan women judges with the International Association of Women Judges. Justice O'Bonsawin holds a Bachelor of Arts from Laurentian University, a Bachelor of Law from the University of Ottawa, a Master of Law from Osgoode Hall School, and a Doctorate in Law from the University of Ottawa. Born in Hanmer, Ontario, a small francophone town near Sudbury, she now resides in Ottawa with her family. A fluently bilingual Franco-Ontarian, Justice O'Bonsawin is an Abenaki member of the Odanak First Nation. She was appointed to the Supreme Court of Canada on September 1st, 2022. Welcome, Justice O'Bonsawin.
So it's my role to act as moderator today, and this is going to be more of a conversation. We'll invite you to maybe think of some questions. I did solicit some questions from students earlier, and I'll begin with some of those. Just a reminder, in case you don't know, that Justice O'Bonsawin cannot talk about cases before the court or cases heading to the court, and she doesn't talk about her family. So with that, I try not to talk about my family. Sorry. No. With that, I'll go on to take the chair's liberty of the first question. Everybody here probably has always had this discussion of this thought in the head. Why did you want to become a lawyer, and why did you want to go to law school? What motivated you?
It's really funny because when I was applying for articles, that's the first question you get asked. Why do you want to be a lawyer? And I had to sit there and talk to my husband, who I had met in law school. I didn't really have a reason per se. I was 9 years old. I come from the Sudbury area, which is blue-collar mining. My father, uncles, the fathers of all my friends were all miners. There were no professionals in my family, so it's not like I had a role model and I said, I'm going to be a lawyer because of this person. It just, my mother has always said the story. When I was 9, I told them that I was going to be a lawyer, and that was it. And that was the plan, and I just kept going with that vision. So in French, we would say, c'est la question qui tue. It's the question that kills. When your first question for your interviews at articles are, why do you want to become a lawyer? And it wasn't necessarily the best answer to say, well, that's what I decided when I was 9, and that's what I was going to do. So that's what it was.
Fascinating. So I grew up in a coal mining town in northeast England, and my sister told me when I was about 11 that I was going to be a lawyer, and that's why I went to law school. She told me. So I didn't even make up my own mind. So anyway.
Did you notice they're laughing? So it's not as bad as talking about contracts.
No,
so
exactly.
We're on a good break.
Exactly. We're good. We've got a good crowd. That's good. So one question to start with. How important, in your opinion, is proper mentorship for new and aspiring lawyers, and what does that mean? What does proper mentorship mean?
Well, for me, it's been instrumental. It started when I was in high school. It's continued to follow me throughout my career. Mentorship for me has always evolved, and I always tell those that I am in a mentorship relationship that don't think you're going to pick one mentor and you're going to be joined at the hip with that mentor all throughout your career. Because it started off in high school, where when I was in grade 12, you go see the guidance counselor and they ask you, well, what are you going to do when you grow up? And I said, well, I'm going to be a lawyer. And he said, oh, Michelle, you come from a small mining town in Northern Ontario. It's really likely you're not going to be a lawyer. And I was so mad, and I said, watch me. So it started off with one of the teachers I'd heard about that, Madame Fournier, and she pulled me aside and she said, you know, I believe in you and you could do that. And as a quick side story, when I was sworn into the Supreme Court last year, I invited this teacher from grade 10 and 12 who supported me. And the most amazing thing happened is she took out an envelope and handed it to me. And I opened it, and inside is something I wrote on the first day of school in grade 10. And she had asked us all to write about ourselves and what our aspirations were and who we were, etc. And I remember my grandfather had been ill. I talked about how I was sad for him because he had shingles, and how, although there weren't lawyers in my family, my goal in life was to become a lawyer. So I introduced myself. And can you believe 30 plus years later, this teacher who was instrumental in my high school years actually brought me back with the year I had wrote. It was amazing. I started to bawl. It was so touching. But then once I got into university at Laurentian, I had a prof, Mr. Cameron, who really took me under his wing, because at that time I had the crazy notion that I had to finish my bachelor's degree in 2 years, which I did. Then afterwards, when I got into law school, I always had been interested on the academic bent. So even when I was a practicing lawyer, Professor Martha Jackman, who is well respected in human rights and women's issues, took me under her wing, and even up until my doctorate. And then throughout my career, so in labor relations at Canada Post, I had mentors there. When I was a judge in the Superior Court, one of the greats in Ontario, Charles Hacklin, took me under his wing. So there's been this evolution throughout, and I've always said that I've stood on the shoulders of giants. So when I was thinking about applying to the court, I consulted one of our greats, Marie Sinclair, and also Phil Fontaine, to ask, was it time, do you think Canada is prepared to start thinking outside the box and to name an Indigenous person to the Supreme Court of Canada? And they really encouraged me to apply. So I've been fortunate throughout my career, and even at the Supreme Court now with Justice Andromaki Karatkazanis, the chief. But I always laugh because, as you all know, I'm not a civilist, so civil code person. So I approached Nicolas Cassira, my colleague, and I said, guess what? I've adopted you as my mentor. Will you take me? So I've been really fortunate to be well surrounded throughout all of my career, and I have stood on the shoulders of giants, and I'm here today because of them.
And what makes a good mentor?
I think it's having an open relationship, because as someone who's been a mentee, I guess, and a mentor, I've been on both ends of it. So to be able to share your knowledge and expertise with the person that you're mentoring, but not to forget that it's a two-sided relationship. So I have to say I've learned a lot from the people that I've mentored. So it's not just me giving, I'm also taking by learning from them. So I think it's having a really active listening, because at times I have quite a few that I mentor, and we try to talk about 5-year plans. I was taught that, I always encourage that. So to have the ability to be able to really listen to what are they looking for, because instead of us just saying, I think this is what you need, bang, 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 it's to have the active listening to say, okay, well, what are you looking for from a mentorship relationship from me? Because I don't have all the answers. I need first to hear, what are you looking for? Then I'll give you my advice on how I think I might be able to help you out moving forward. So I think it's a give and take.
One of the law review students, so this follows on from that, says, since there was little Indigenous representation across the duration of your career, did you ever find it challenging to envision yourself in certain roles or positions? And again, who did you look for advice and guidance in that?
Well, my goal was to be a lawyer. I'll be honest. I never would have thought in my wildest dreams that I could be a judge. This little kid from Northern Ontario, who thought that was told wouldn't be even a lawyer. Here I am, a judge. It was not even a possibility. And when I started, the light went on in law school. We were in legislation our first year. We had the Commissioner of Judicial Affairs came. And he was explaining to us, how do you become a judge? So 10 years of service and a good reputation, etc. And at the end of this conversation, I'm sitting in this room with all of my colleague students. Someone lifts their hand and says, well, what's the perfect candidate? And back then, we had our Aboriginal Law Students Association. We were a handful. And in the French Common Law program, I was the only one. And so the student asked, well, what's the perfect candidate to be a judge? And he said, a bilingual Aboriginal woman. I thought, oh my God, that's me. I never would have even thought of it had the commissioner and, someone said, hey, what's the perfect candidate? I thought, okay, this is the next goal. So after I started in my practice, I was fortunate when I was at the Royal, because I used to appear in front of the review board for forensic psychiatry. Those are for those that are found not criminally responsible or unfit to stand trial. And the main president who sits on those boards are retired judges. So I was fortunate because a lot of them talked to me about becoming a judge, what would it look like, what do you need to do? So I was really fortunate to be surrounded because of my forensic psychiatry environment to learn to work with them, and also because of the work I was doing at the Royal, I worked a lot with our regional senior judge who was responsible for assigning cases when I needed interim treatment orders. So, and that was Justice Charles Hackland, who I talked about, who became a mentor. And he was one of my references when I applied to the Superior Court. And he had told me, Michelle, when you'll be named, I'm going to be your mentor. And he is the first person who called me when the news came out to say, remember my offer? Well, this is it. I'm your mentor. So I was fortunate.
Well, another question which follows on nicely from this. One of the law review students said, you have a legal path that I admire, often working as in-house counsel for large public organizations such as Canada Post, the RCMP. How do you think that background in public legal work has influenced your development as a judge or your work with the Supreme Court?
I've been really fortunate because I've always considered myself a bit of an oddity to be a litigator like I had been throughout all my career and always having been in-house. And I always encourage those that I mentor, think outside of the box. The be-all and end-all is not going to Bay Street in Toronto or to the big firms or to become a Crown, etc. Think outside of the box because there's a lot to be had of litigating in-house. And I've always seen it as beneficial because my friends were at big firms or mid-sized firms holding the bag of the senior lawyer for 5+ years, and I was in a sink or swim model where I got my first case. I had my mentor. He said, you're going to do ABC. I went out there with and I'll never forget my first hearing. I went out there with my little book of authorities, and at the end I was so nervous, I packed all my books and I got back to my office and I took my stuff out and I didn't even give my book of authorities to the arbitrator. So it was a wonderful learning experience because you got to see what being an in-house litigator is, which is extremely exciting. I got to see all of Canada through my work at Canada Post from east to west. And you get to see the public relations side of it and also the governmental side because the Minister for Canada Post wore 2 hats, was responsible for Canada Post and also another ministry. And then I went into the provincial system looking at the mental health side, and that's a whole different regime when you're looking at a provincial entity. So it was nice to get the perspective of working in a federal regime versus a provincial one. So I was really lucky. I got a well-rounded experience being an in-house litigator, and I did really amazing work because of that.
You've touched on the issue of mental health, so another question. You have extensive experience within the area of mental health and mental health law, particularly, again, mental health issues in a legal context. Do you see any worrying or any positive trends with regards to mental health issues, the legal professionals, or the treatment of the mentally ill in the legal system?
I've seen an evolution because when I started off at Canada Post, I'll be honest, I did a lot of labor law, and a manager would have someone who was not coming to work. They were suffering from depression. They couldn't get out of bed. And the answer was, well, we're going to discipline you. You're not showing up. Take your medication, come to work. And I have to say, from that time, I saw a huge evolution where employers, there's a lot more discussion. There are a lot of different corporations, like, for example, Bell Let's Talk. So from the time I started Canada Post to the time I started at the Royal in 2009, there was really, I could see an evolution where employers were getting a better understanding of the impact of mental illness on the work staff. There was an evolution about the destigmatization, because it's not like a cast where you could see the injury visually, so everyone knows you broke your arm. When you suffer from mental illness, it's completely different. It's silent. It's something that can't be seen to the naked eye. So I did see the evolution. Are we where we should be? Absolutely not. I think we have a long way to go. And I think in the legal profession itself, we even have a long way to go, because last year, University of Sherbrooke, along with the Canadian Bar Association, published a really amazing research that I recommend all of you to look at. And it talks about the impact of mental illness on us who work in the legal field. And it talks about things that we know of, that 50% of the people in this room are touched either directly by the personal impact or someone that you love who is touched by mental illness. And these are things that we have to talk about so that there's not that stigma and shame to ask about and to ask for that help. So even in law schools, there are accommodations that are made. So we've had a lot of headway. When we look at forensic mental health, those that are found not criminally responsible and fit to stand trial, there are still significant issues, because a lot of the population, it's sensationalized in the media. You'll see Alan Schoenborn, Vincent Lee, the other one, Dr. Turcotte. These are individuals that have been sensationalized, where people think, oh my God, they've been found not criminally responsible. They have to be really bad to the core. But when you look at different research that has come out from Dr. Cito, who was a former client of mine, it shows that the risk of recidivism rates for those that are found in CR unfit to stand trial are much lower than those that are actually sent directly to prison. So because there's the active treatment. So I think that it's a system that works. I know in 2019, when I was invited to go to Italy to talk with a group of other treating psychiatrists about whether or not we should deinstitutionalize forensic mental health in Canada, we were opposed to it. And the reason being, in Europe, there was this whole vague of them wanting to stop the forensic mental health system and just send everyone to jail. And I don't believe that's where we have to go. I think with the provision of mental health services, people are less a risk to themselves and to others. So I think it's a positive change, but we are moving in the right direction. But I'm really hoping that all of you are going to be instruments of change, because you're our youth and our generation of future lawyers. And I want you to say two things to you. One, recognize that indirectly or directly, everyone in this room is touched by mental illness. And two, be really mindful when you're dealing with, later as lawyers, with the people that you work with, to ask those questions and to be compassionate and sensitive of those that are touched by mental illness.
Thank you. Some questions about preparation and judging. So you've mentioned that one of your mottos to be, quote, prepare every case as if it's your first one. What are there any specific tasks you could recommend for new lawyers to get in the habit of doing when preparing their cases?
That's the best piece of advice my mentor at Canada Post, Phil Dempsey, gave me. And what I would recommend is what he told to me. So when you're looking at your file, make sure you understand, first of all the facts. Get a good understanding of what your position is. What is the position of those that you're on the other side of? Make sure you know all the weaknesses on your side, what the responses are to your weaknesses, because as judges, trial judges, appellate judges, we ask questions. So if you're just going to follow your script, be prepared. You're going to be thrown off course. So how do you not get thrown off course? You have to know the facts. You got to know your position, the position of the other side, weaknesses and answers to both sides. and try to think outside of the box. What kind of questions are you going to be receiving from either the individual judge or the panel that you're appearing in front of? Because don't get married to a script, because I think that's the worst thing anyone could do. I know when we start off in the law, we're nervous. That's normal, but I really encourage you not to sit there and write everything out, because if you're thrown off by a question of a judge and you can't find yourself back in your notes, it's going to be really difficult. And sometimes just sit in front of the mirror, practice, practice, practice. That's the best way you can prepare to litigate in front of a judge or an administrative tribunal.
Yeah. Our 1L students will be doing their first year moot in the next couple of weeks, so I think they're...
So prepare, prepare,
yeah,
prepare.
Absolutely. Yeah, good advice. Now, a couple of questions about judging. When you make a decision to overturn or overrule a lower court decision, do you find yourself focusing more on the past and precedent or the future impact of any change or any decision you might make?
Geez, that's a hard one. I think it really depends on what the issue is before you. Sometimes you want to fix something that's in the past because of the parties that are in front of you. Sometimes you're looking forward. I think in our court as the Supreme Court, we have the national jurisdiction. So in my mind, we should be looking forward, not so much looking back. Because at the end of the day, the law evolves. It is a breathing, living tree. And we have to evolve with the times. Think of things that have happened in the past with MAID, abortion, same-sex marriage. Imagine if we were doing like some of our neighbors are going backwards instead of forwards. So I think as a legal society, we have an obligation to move with the times, learn from the past, and move towards the future in a positive way. I'll say even maybe progressive, to be able to move with the times. So I think we're not necessarily looking back. We got to look to the future.
I got two more questions, then I'll be opening up the room. So for those who have questions, this one, we'll see if you want to answer this one. What are your thoughts on the requirement that Supreme Court justices be able to speak both English and French? What impacts might that requirement have on Indigenous legal professionals who are seeking bench involvement or appointment who perhaps speak multiple languages, including their own Indigenous language, but do not speak both English and French? Is there space for reform? Do you want to switch off the live stream right now? We can probably do a media blackout. You can.
Yeah, I will just say that I am supportive of it. I have to say that Justice Moldaver was the last purely Anglophone who sat on the court. And with my arrival, I have felt comfortable to speak in my first language, which is French. So if we hear a file in French, I speak in French. If we hear a file in English, I speak in English. I'm talking about me personally. For me, I find it beneficial. So even if I hear a case, so my first solo decision came out a couple of weeks ago in Brunel. I heard it in French, I wrote it in French. If I hear it in English, I write it in English. So I think there's the benefit not to have simultaneous translation, but I'm talking about for me, who's perfectly bilingual, I think it's a plus, but I understand from my friend Harry Laflamme that he's written a lot about this, about the discrimination that it has with regard to our Indigenous colleagues who are bilingual but not in the two official languages. So I understand that side of it, and I guess that's all I'll say.
Yeah. And one more question, then we will open up. Being the first Indigenous Supreme Court Justice adds, whether you want or not, a sense of responsibility. How do you carry that responsibility?
I always laugh. I tell Mary I have really wide shoulders. Listen, at the end of the day, I've been first at different levels throughout my career. I try to take it in stride. I know at times I feel the pressure. We have different cases that are in front of us, but I want everyone to remember I'm one of 9. I'm not the one who's the be-all and end-all. I'm a voice with regard to my unique background and my lived experience as a Franco-Ontarian Indigenous woman, and these are the things that I bring to the table, like some of my colleagues who have their own cultural, personal lived experiences. I think we're all unique. We all bring something, and it is what it is.
Okay, I'm going to open it up to the floor. Yeah. And please use the microphone. Anybody have a question? I have lots more in my head.
That's always the bad thing when
Yeah.
no one asks us question. Watch out, I might break out into something here.
Yeah.
I'll ask a question.
Okay, go ahead.
Could you explain the impact of Indian residential school, Gladue factors, mental health, and the over-incarceration of Indigenous people in Canada? And how can the courts address these impacts of colonization?
Well, I'll start off by saying that I think that Gladue principles are instrumental, and I had made it part of my response to the 94 calls to action when we're looking at education and justice. I thought it was always important for me as a person who was academically bent when I was a litigator and then afterwards as a judge to educate as many as I could with regard to what the impact and what Gladue principles are, because unfortunately some of our colleagues on the judiciary aren't necessarily in tune with that. So whenever I had the opportunity under the National Judicial Institute, etc., I took advantage of it. I published things to hopefully help some of my colleagues to be mindful of it, because there is that obligation under 718(2)E to think about the personal background of the accused, the Indigenous accused that appear in front of us, because I think that that has to be front of mind. And unfortunately, it's not always the case. So the impact of intergenerational trauma, residential schools is significant, and it's definitely a big contributor of why we are 5% of the population, but unfortunately our women are around 50% and our men are close to 35% of those that are incarcerated. And when you look 5% and these high numbers, it makes no sense whatsoever. A lot of people ask me, what's the solution? I don't have the solution. I think it starts at the base. We as a people have to heal, but we also have to educate and try to move to the next steps and help ourselves to get through this. I think that there has to be work hand in hand between governments, institutions, and society as a whole to try to help our people to get out of this difficulty that we face with these unacceptable numbers. So I could play my small part, and that's why when I wrote that article, I wrote everyone has a role to play, because it's not just the judges, it's the lawyers, it's the clients, it's the whole judicial system that surrounds it. It's the community that is hoping to uplift and help these individuals that are in this situation. So it's an intertwining of all different things, and I think everyone in this room has a role to play to try to improve the plight of what we're seeing.
Thank you. Dominique.
Hi.
Hi.
Do you think there's space in the Constitution for housing rights?
All right, well, that's one of those questions that I will pass. You never know, it sounds like something that could definitely come forward, but if you have anything else I could answer, go for it, now's the time.
I'll ask while we're getting some else to microphone. So you were telling me, and we've been working with you, that every place you visit, you go and visit Indigenous students in a high school. Can you tell us why you do that and what the importance of that and why that's so important to you to do that? And you're going to Bedford Road tomorrow to meet with students tomorrow. So tell us a bit about that.
I think it's really important because when I was in high school, I didn't get to meet any lawyers, forget any judges. And we're all role models to our youth. So I've decided as of this year that whenever I'm invited to speak at a university, I ask the university to recommend a couple of different high schools that have Indigenous youth that I can go and meet with. Because if I could hopefully inspire one person to make a difference, that's enough for me. So yesterday I was in Winnipeg, so I went to Seven Oaks MET, a really awesome school that's not the normal teaching regime that you would see in the provincial system. So that was great. I spent a couple of hours there. Tomorrow we're going to be doing the same here. We're going to start off our day by doing a smudge. So for me, this is part of giving back. It's sharing my road of how I got to where I am now, but also I hear from them and it energizes me. It gives me hope because I think our youth are our future. So I really enjoy it. I love meeting with people, but I think universities are great. But the thing is, everyone's decided pretty much when you get here. But if we go to a high school, it's really different because that's when people are starting to think, this is what I want to do, or maybe I'm at a crossroads. So I think it starts with our youth, and for me, it's really important to meet with different high school students. And it's funny because every once in a while, my assistant laughs. I get what I call a cold call, which we would get in a law firm, right? But I get these invites from different students. Like I'm doing a school of grade 5 in Manitoba, and I do them online. So at times, there's a brave teacher that writes to my office and says, can you spend a half hour online with my grade 5 or grade 6 students? And I do it.
Good. Kate.
Hi, thank you for taking the time to speak with us today. I
Hi.
have a question about access to justice.
Yep.
The Supreme Court has recently adopted an e-filing system. I was wondering, what role do you see technology playing in promoting access to justice, and if there's anything that you think the court could do to make the court process more accessible?
Well, I think it's really evolved. The silver lining of COVID has been that it's improved access to justice on the IT side, because a lot of times people weren't able to drive to get to a location. They're in a remote area. So I think it's highly improved access to justice because of the IT components. So for example, in Ontario, the federal court and the Supreme Court of Canada were way advanced to what we were seeing in our Ontario Court of Justice and our Ontario Superior Court and the Court of Appeal. And this forced the government, MAG, to put funding in to put us into the times, because I have to say our courts were way behind to some of what our colleagues were doing. So from what I understand, the Supreme Court, they had been ahead of their time, and they just kept rolling. They didn't break, whereas we screeched to a halt in our OCJ and our SCJ courts in Ontario, where for a couple of weeks we didn't sit because we didn't have anything. And I have to say, I live a bit more remotely in Ottawa, but on 6 acres, and my internet was wonky. I wasn't even able to do Zoom hearings. I had to do it old school with a phone line. So I think if that happens to me, it happens to a lot of people in remote communities. So I think there's still a lot of issues, but it's a step in the right direction, and e-filing even better, because then you don't have someone who's driving hours and hours to go file like 5 pieces of documents. So I think definitely we've seen a huge improvement because of the pandemic. And hopefully, I understand the government of Canada says it's going to invest all this money to make remote areas more accessible, and that's just going to improve things. And as we know, we've seen with, Starlink. I think that in the last couple of years has been an improvement. I know in my own personal life it's made a difference, because now I actually have reliable internet. So who knew?
Another question over there.
Hi. What's your name?
My name is Josh.
Hi, Josh.
You spoke earlier about how part of your responsibility as a Supreme Court Justice is to kind of move the common law forward. What kind of principles do you base those decisions off of?
What kind of principles? I think it's based on what the files are as we find them. So I don't think any of us go into hearing saying this is automatically what's going to happen. As a judge, as with any court, we base our decisions on how they're argued in front of us, the evidence that's been put towards us, the arguments of the parties. So I don't think there's a principle per se. Of course, you're thinking, depending on the matter, it's charter-based. You're thinking about charter principles. It could be on different things like sentencing, where I'm thinking about Gladue principles. Could be on sexual assault, where I'm thinking about the interpretation of 276. So I think it really depends on how the case is presented to us, and then afterwards you take it from there. But of course, everyone's always cognizant. A lot of the cases, especially in criminal, we're thinking of charter-based issues. So
So this is a Dean's question. You'll probably get that, and then I'll come to Jerry after that. So You have an impressive academic record with a master's degree, a doctorate, and one of the perennial debates in law school, and we have fights with our students and our colleagues over this, is the trade school versus academic institution and where the balance and where the blend is between academic theorizing and practical legal skills. And legal education is evolving. Where do you sit on that? Because you have a unique perspective. So what would you say to the students about the importance, say, for example, of theoretical perspectives while you're studying, and also where do you think the balance should be?
Well, I'll be honest, anyone who I mentor who's thinking of doing a master's or more, I always tell them to get practical experience first. I saw a huge difference of having worked for 10 years as a litigator and doing my master's degree. I thought it was a breeze. If I had done that after, no, but 10 years of experience makes all the difference in the world because you know how to write. Your analytical skills are more developed. You've been doing this for 10 years. If you're jumping directly from law school into a master's program, your skill set, and this is my humble little view, I don't think your skill set analytically, research, is not as developed. So I think there's a lot to be gained of having that practical experience if you want to go into the academic world. And if you love it so much and you stay there, even better, because academics are forming our lawyers of the future. But I think that there's a lot to be said of having that practical experience before you get into the academic world. I remember when I was sitting as a judge and I took 2 years off of my PhD program to figure out how to be a good judge. And when I decided to go back, I told my regional senior judge, and he says, well, why do you want to do that? You don't need this. Like, you don't need your PhD. And for me, it was important because I thought that my research in the end would be value added, and I'm hoping to publish part of it this spring. But I thought it was just important for me personally because I also wanted to show my sons that you start something and you finish it. So I think that there's a lot of benefit of the practical approach. So sorry if there are professors here who haven't had the practical work first, but I believe in that.
Thank you. Judge Moore.
Yeah, welcome to our territory.
Thank you.
My question is, from the day I left home back in the 60s to go to high school somewhere, I've always been confronted with, how come you guys do this? How come you look at things differently? In other words, we were always expected to have the answer to everything about Indigenous people. And throughout that process, I educated myself because I was a product of bad education too, where a lot of people come from. Now, just to move forward, judicial education. Do we have enough in terms of judicial education, in terms of Indigenous areas of law? Because I started involving myself with Indigenous law when I was just a mere lawyer, and the Western education person, it was Justice Douglas, I think he was involved with it. He involved me in my first year practicing. What did I know? Nothing. But now I look at judicial education differently. It's important. Do the Supreme Court access themselves to judicial education in Indigenous areas, or they feel they get enough from all the factums that they ever get on Indigenous law? Like, is there room for that?
I think definitely there's room for that. Do my colleagues do that? I have to tell you honestly, I don't know what they do. I know what I do. I've been asked, a lot of them when we have Indigenous cases will come and consult me and say, what do you think? What do you know? So that happens, and it's happened throughout all my career because that's what happens, right? We're all consulted to see what we think because we're Indigenous. I think that there should be probably more across the board for judges globally or nationally, I should say, in Canada, because of course we have the bench book for those of you that don't know, the National Judicial Institute, different judges have created bench books, which are the Bibles of all the different topics. And there's one on Aboriginal law, and there's one on, taxation and corporate and all these different things. And but at times I think what happens is we forget that we shouldn't just be learning from a book. We should be learning from our elders and those that have that knowledge that we seek. So I think there's always room to improve any kind of judicial education that we get, and I think it's really important. And I know since I've joined the Supreme Court, for me it was important to be sworn in on an eagle feather. My colleagues didn't know what that meant. They had, I think, their own ideas, but it was part of me educating them how we were going to work with an elder from Kitiyan-Zibi, who's associated with the University of Ottawa, Gilbert White Duck, who was going to bring the eagle feather. I wanted to ensure that I was going to have a smudge in my office before I went and did my formal swearing in with my colleagues. So there was a lot of education component to my colleagues, but not just that, even to my clerks. So when I started with my new rounds of clerks, I did a smudge outside with them, and I explained all the processes. And another part of their education was I took them to my First Nation, because we were celebrating our survival of Rogers' raid. Rogers, when our men were all gone, the Abenaki men were gone to fight on the plains of Abraham against the English. Rogers from the States decided that he was going to come and invade our territory, and we had received word, so all of our women and children hid in the cornfields while our territory was burnt down. But we celebrate our survival in October, and I brought all of my staff with me so they could come and experience and learn from our elders, have a traditional meal, and walk through the streets to celebrate our survival. So that's how I treat my staff, for me to share with them, because they're not Indigenous, and I think it's important. And I talk about these things with my colleagues too, so it's a mix of both, but I definitely agree, Jerry, there's more to be done.
Hi, it's an honor to hear from you today, so thank you for being here.
Hi, thanks. What's your name?
Amy,
Hi, Amy.
in your opinion, what role does the judiciary play in advancing reconciliation between Indigenous peoples and the Canadian state?
Well, I think everyone has a role to play, so I'm sorry I keep being redundant and saying the same thing, but I think everyone has a role to play. I think judges have a responsibility to learn what our obligations are under 718(2)E of the Criminal Code when it comes to sentencing, when it comes to the more recent amendments to the Criminal Code in the last couple of years with regard to bail provisions. I think that judges that are sitting in communities that are near First Nations, it's worthwhile to go visit the communities to learn about them. So I think that it's an important thing. You got to learn about the community and who they are. One of the things that I strongly recommend everyone to learn about who are not Indigenous is to read the summary at the beginning of the TRC report, to really get an understanding of the impact of residential school, the intergenerational trauma, etc. Because I think what's happened, and I'm sure a lot of my colleagues here would agree, is until Kamloops and the discoveries came out, I think a lot of people had their heads in the sand, and they weren't really thinking it was as bad as everyone was, like Murray Sinclair and the commission had said. And I think this actually brought the reality into the spotlight throughout Canada. So that's why I encourage everyone who really wants to get an understanding of the impact of residential schools to read the executive summary at the beginning of those reports. And that's a part of reconciliation, because the more you know, the more you understand. Or the more you learn, I should say, the more you're going to understand.
Okay, I think we have time for 2 more questions, so over here.
Well,
Hi.
I'm in education, not law, so I was just curious.
What's your name?
Annika.
Hello, Annika.
I was just curious as to what your thoughts are on how the legal system can partner with educators to target mental health at younger ages with students.
Well, I think the first thing is to talk about it. When we're looking at mental illness in education, it's always been there. I think that a lot of the high schools, for example, are integrating social workers. I've been a huge fan throughout my career working in forensic mental health of social workers, because I think they're the link between the institution but into the community, and how to access those services that are really needed of our students. So I think it starts at a young age. It starts with the recognition of the institutions, the teachers, to identify when they see a student is touched by mental health issues. And then when we get into the university sphere, And we're looking in, for example, the Sherbrooke report that came out not even 2 years ago, and it talks about the significant issues that law students are dealing with when, especially in first year. We all went through it. You know how brutal it is after your first set of Christmas exams? I'll be honest, I cried after my Christmas exams because I wasn't prepared. I didn't know how to study. And it was really tough. And my husband said, you should have studied more. And I'm like, yeah, you were right. But I think that there's a huge role to play institution-wise, and I think that I'm happy to see a lot of universities have actually created programs to help assist students that are in need, because I think that now that we're trying to destigmatize mental illness, we're talking about it more. There are campaigns that are talking about it. I think it's a step in the right direction, and I'm hoping that by working hand in hand, and I've also met through different universities, there are student-led groups that have their own chapters. And I think I met a group from U of M yesterday, and I was really happy to see that, because when I was in law school, no one talked about that. It's not something ever anyone discussed openly because everyone was ashamed. And now it's different. There's still stigma. It's never going to be gone, I think, at this point 100%, because there are those three categories I normally talk about. Those that are directly touched by mental illness, those that have a family member, a friend, or a colleague that's touched and they're a supporter, and those that really do not believe in mental illness. And for those, that category 3, the naysayers, I always say, at least try to understand and learn what mental illness is and how it impacts people. And with knowledge is going to become understanding. So,
One last question.
I
Hello.
actually have two because I'm
okay,
not
what's
sure.
your name?
Okay.
My name is Ifani.
Hi, Fanny.
Good afternoon, Ma. So my first question, I hope it falls within the kind of question you can answer.
We'll see.
I'll do the second one. Okay, so it's about access to justice, but courtroom and dispute resolution context. In your personal opinion, do you think that the right to counsel is, or having representation is important or sine qua non for people who use the court system, particularly in civil cases? And if your answer is yes, then do you think that there will ever be a time in Canada where, like, the law would grant or help people have more access to counsel or representation in courts or administrative tribunal?
So I guess I'll answer this in a general way. I think having counsel, forget right to counsel. I think having a counsel for anyone who appears on civil matters is beneficial. It's beneficial to the individual who's in front of us, but it's also beneficial to the justice system as a whole, because when we have self-represented litigants, a lot of times different things happen. It bogs down the system because they don't understand the rules, they don't understand how to file documents, they don't understand the civil procedures. So I think that if they could meet the requirements, and this is an issue I won't get into too much, but as we know, there are problems with legal aid. And what's the baseline to be able to meet the requirements? And unfortunately, a lot of mid-level people make a bit too much money to qualify for legal aid. So we see it a lot in family matters that all these individuals appear in front of us and self-represent because they're just shy of meeting the target to get legal aid. So my honest opinion is that everyone can benefit from having legal counsel unless you're legally trained, because that does happen, because it helps the person to have a better, I guess, a better result in the system, and it also helps the judicial system not get bogged down and move forward.
Thank you very much. And the second and last is,
Okay.
I'm not a judge, by no way, but I've practiced law.
Maybe you'll be a wannabe.
Probably. I've practiced law for a while, and I've read, of course, practicing law means you read a lot of cases, and my opinion is that, I don't know, that many judges, when cases come before them, they're already, like, know what they want to decide, and then they get the authorities and like support that stance. I don't know, how do you approach cases? Do you, like the arguments lawyers give, like do they really inform your decision, or you already come to a case with, okay, this is how I'm going to decide it. Whatever you say, that's your business. And then you can always find support for any decision you want to give, right? So how do you approach?
Well, on that, I'll just tell you as a trial judge, forget a Supreme Court of Canada judge, as a trial judge, you always read your material. So my husband always told lawyer friends of ours, if ever you appear in front of Michelle, make sure you read, that you know your material, because she'll have read it and she'll be able to ask you questions that you don't know the answers to. So I think, yeah, I don't think I'm going to answer that one.
Very good, very good. Okay, well, I wish we had more time, because this is fascinating and engaging, but unfortunately we have classes to go to and you have some appointments. So I'm going to ask two things. One, I'll ask the audience to just hold their applause until Laura, one of our managing editors, says a few words of thanks and presents a gift to our guest.
Justice O'Bonsawin, thank you so much for coming to speak with us today on behalf of the College of Law and the Saskatchewan Law Review editorial board. We're just so honored to hear a little bit about your story and also some of your advice. So thank you so much.
Thank you very much.
Thank you. That was a pleasure.
That was great. Thank you so much. Thank you. I really appreciate just a couple of closing words. I had received this invitation last year. Unfortunately, I wasn't able to come. And I'm really happy to be here and to visit with your dean, all the students, the different community members. So thank you, Uliuni. It really warms my heart to see everyone here. Thank you.
Thank you. Thank you very much.
Thank you.